Hello everyone, welcome to the channel Low Point and this is Anisha Babu. Today is our second session of the Dowry Prohibition series. For the rich, dowry is seen as status symbol. For the middle class, it is a financial burden. And for the poor, it is a curse. To prevent this shameful practice, each one of us need to take a systematic approach towards its prevention. We have a Supreme Court of India's advocate on record, Mrs. Praseena Elizabeth Joseph, to explain us various legal provisions dealing with prevention of dowry. So let's watch.
There are various laws in India dealing with prevention of dowry. The prominent among them is Dowry Prohibition Act of 1961. Apart from this act, there are provisions under Indian Penal Code, Code of Criminal Procedure, Indian Evidence Act, as well as under Protection of Women from Domestic Violence Act. First of all, we will deal with Dowry Prohibition Act of 1961. This is the first national legislation relating to dowry prohibition in India. This act defines what is dowry. Dowry means any property or money or goods given by anybody in connection with marriage. The definition of dowry under this act is used under Indian Penal Code, Code of Criminal Procedure, Evidence Act, as well as under Protection of Women from Domestic Violence Act. Under Dowry Prohibition Act, demanding dowry, giving dowry, as well as taking dowry are punishable non-bailable offences. That means when a complaint regarding demanding or giving or taking dowry is reported, the police can arrest the accused, and the accused, when he is moving to the court for grant of bail, it is the discretion of the court whether to grant bail or not. If there is a demand for dowry, then the person who has demanded dowry is punishable with a minimum imprisonment of 6 months and which can stretch up to a maximum of 5 years and shall also be liable to fine of rupees 15,000. If there is give and take of dowry, then the accused persons are punishable with a minimum imprisonment of 5 years and shall also be liable to fine of rupees 15,000 or the value of dowry, whichever is more. Now let's see the provisions under Indian Penal Code dealing with prevention of dowry. The Indian Penal Code intends not only to prohibit the dowry system in India but also to prohibit the violence related to it. There are two circumstances where a married woman is subjected to harassment and cruelty in connection with dowry, which are considered as offences under the Indian Penal Code. The first is dowry death. That means death of a woman is caused by either burns or bodily injuries or under unnatural circumstances. Further, this death has occurred within 7 years of marriage and the deceased woman was subjected to harassment or cruelty concerning dowry demands soon before her death. The punishment of the accused of dowry death is minimum imprisonment of 7 years and a maximum of life imprisonment. Second offence under the Indian Penal Code relating to dowry is cruelty caused to a woman by husband or relatives of husband. In this case, cruelty or harassment includes both physical and mental torture. Any conduct of husband or relatives of husband in unlawfully demanding dowry and intended to provoke a woman to commit suicide or to cause danger to her life or impair her mental or physical health are all forms of harassment or cruelty. They are punishable as an offence. Punishment is imprisonment which can extend up to 3 years and shall also be liable to fine. Now let's see what are the provisions under the Code of Criminal Procedure dealing with dowry. We have seen Dowry Prohibition Act as well as Indian Penal Code. They define offences as well as prescribe its respective punishment. However, it is the Criminal Procedure Code which prescribes the procedure as to how to deal with these offences and punishments. Code of Criminal Procedure prescribes two ways of filing a complaint relating to dowry harassment. First of all, you can complain to the nearest police station. Secondly, if the police is not lodging your complaint, then you can file a private complaint before the court directly. The court takes cognizance of the matter on a police report after investigation as well as on a private complaint filed by the aggrieved woman or her parents or her siblings, etc. Now, let's see the provisions under the Indian Evidence Act dealing with dowry. Evidence Act deals with how evidence need to be gathered in a case. The general principles of our criminal law is that from the day a crime is reported till the day the accused is found guilty by the court of law, the accused is presumed innocent by the court, and the burden to prove that the accused is guilty beyond the shadow of reasonable doubt is on the prosecution. However, in dowry related cases under the Indian Evidence Act, this benefit of presumption of innocence available to the accused is not available. It is presumed that the accused has committed the crime relating to dowry, and it is for the accused person to prove in the court that he is not guilty and he has not committed the offence relating to dowry. Finally, we can find dowry related provisions under Protection of Women from Domestic Violence Act. This act provides an additional layer of protection to women from dowry harassments. Under this act, any harassment or injury caused to a woman in any unlawful demand for dowry is considered as a domestic violence, and punishment in the form of prohibition orders, compensation orders can be awarded by the court. Thank you.
Thank you for watching. Stay tuned. Till then, take care. Bye-bye.